also a member of the Sorority Incorporated. I present to some and introduce to others none other than the Professor Angela Allen Bell.
Good afternoon, everyone. I wanted to just scrap that long introduction and just say that my proudest moment is joining Zeta Phi Beta. And it is an honor tonight to have this blue and white on and to be in your midst. And this is not only a talk for me, but this is as well a personal crusade. So I thank you for giving me this moment to talk to you about something that is very dear to my heart. And I hope that I will galvanize folks tonight so that we will begin doing this work together. So I'm going to start taking us back to some history about race and juries and political rights, both in the state and in the nation. And then we'll move forward to the present and what it is that I'm hoping to ignite a movement around. So when we think about the right to a jury trial, we think about it being enshrined in some really significant documents. We see it in the Magna Carta. We see that right to the jury trial in the Declaration of Independence. We even see it in the United States Constitution. And so by it being placed in these places, we would think that it is some cherished protection in this country. We would believe that it is a very preciously guarded right in this country. But in law, what I have learned after 20-something years as being a lawyer, there is such a thing as an ideal, and then there is such a thing as practice. And when it comes to our legal system and people of color, whether they be the accused or whether they be the juror, they rarely get the ideal. More often, people of color get the custom and they get the practices. And so for them, jury trials and voting and public office holding, they're all inescapably intertwined with race. And it is impossible to separate them. Some would even argue that there is a matrimony of sorts between race and jury service and race and public office and race and the vote. And so you may be wondering, well, when did this union happen? And so for that understanding, we need to take a journey all the way back really to the end of chattel slavery. And this is a very critical hour in the history of this country because when chattel slavery ended in 1865, the nation is struggling with some really critical questions about what's going to happen to reconstruct itself. How does it integrate these newly emancipated people who were pieces of property? They had no legal rights. How do we convert them from property, which is what they were in chattel slavery, to now beings with these legal rights? They're citizens for the first time. So the nation has to answer these very difficult questions. Questions like exactly what did you mean when you freed them? By way of that 13th Amendment. What do you mean when you call them citizens by way of the 14th Amendment? Exactly what rights do you intend to give them when you emancipate them in this country? Do you want them just to have these things called civil rights? Is that enough? Or do you want them to have the greater protections called political rights? And by political rights, I mean the right to participate on a jury. I mean the right to be able to vote. I mean the right to hold public office. These are your three political rights. And so I want us to think about the first Civil Rights Act that we get in this country. It is all the way back in 1866, literally a year after emancipation. So we start the business of civil rights pretty promptly after emancipation. And if you read the congressional record, surrounding the debates of this 1866 Civil Rights Act, they illuminate these perplexities that I'm speaking about tonight. You will see on that record James F. Wilson speaking to Congress, and I'm going to quote him just so we can feel what this journey would have been like for the country back in 1866 as they struggle to shape what this new nation is going to be like, where rights are going to be given to these newly emancipated people. So Mr. Wilson says to Congress, and I'm quoting now, When you talk about freeing them, Mr. Wilson says, do you mean free in all things? Do you mean that they're going to have civil rights and social rights and political rights? Do you mean that they're going to be citizens without any distinction of race or color? He said, by no means could you mean that. This is what he's saying on the floor of Congress. Do you mean that they would actually be able to vote in all of the states? Do you really mean that? He's saying, do you understand the vote is a political right? Do you mean that you want them to sit on a jury? Do you really mean that you intend for them to go to the same schools with our children? He said, these are not the rights that I had in mind. These are civil rights that I thought we were giving them. Civil rights meant simple things like just the right to personal liberty, the right to have property, the right to maybe move around. But I didn't mean, he says, these political rights. That was not what I thought when I thought of emancipation. And so what we start to see on this record is that their vision for freedom was just the grant of civil rights, mobility, property ownership, some personal rights. But it was never to go so far as the right to vote and the right to hold office and the right to serve on a jury. Why? Because those rights are rights that allow people to navigate life. Those rights are rights that give people true power in a society, and they were not exactly ready to confer those rights over to the newly emancipated people. So what happens when Congress forces these rights? The southern states resist, and they start with the vote. So we're going to talk separately about how the southern states reacted now to Congress forcing these political rights that they never intended for us to have as a result of emancipation. Why was the vote so important to them? Because at this hour in the country's history, the vote was a weapon. The vote was power. The vote was the ability to influence a system that had been controlled by few. And they were not willing to surrender that power. They understood that if the vote were conferred, then there would be some type of exchange of power, and they were not ready to have that happen. So we see voter suppression almost immediately after emancipation. So by the time we get the 15th Amendment in the 1870s, that's federalizing this voter protection right. The 15th Amendment is saying that no state can take your right to vote. That comes in 1870, but simultaneously with that written promise that no one can take your right to vote, we have lynching happening in this country. So that is the first voter suppression tactic. It was lynching. And then the next method was actually domestic terrorism to suppress the vote. It was literally massacres throughout the state of Louisiana. Many of those massacres, by the way, have largely been suppressed. So we need to be aware of the magnitude of the effort that was involved in suppressing the Black vote from the time we got the 15th Amendment. So I'm thinking about the Mechanics Institute riot down in New Orleans. I'm thinking about the Opelousas riot, the St. Bernard Parish riot, the Battle of Liberty Place. And then, of course, we cannot overlook the Colfax massacre, which takes on extreme significance at this hour. So I want to talk to you about what just happened in Colfax as we talk about this suppression effort to stop the Black vote. What you see is a marker that had been publicly displayed from Easter of 1873 all the way until the 2000s, rather. I want you to look at the words on this marker. It's 2 sentences, and it marks the site that white Colfax residents decided that they were going to slaughter Blacks who had registered to vote. Now, I want to emphasize they were doing what was legal. But the Constitution said they could do that day, and this marker was put outside of the courthouse in Colfax, And if you look at line 2, what it says is that this is being put here to make the world understand what happens to you, Black folks, when you want to get out and register to vote in Colfax, Louisiana, and think that you are going to shape the outcome of elections. Now, those words in line 2 happen to be bad. Of course they are, but that's not the worst thing about this marker. The worst thing about this marker is when it was put up and by whom. And so this marker is memorializing events that happened in 1873. Guess when it went up? In 1950. So that tells you about a state all of those years removed from 1873 to 1950 that is still proud of the idea that it killed people, it slaughtered people for doing what the United States Constitution gave them the legal right to do. And worse than the fact that it's being celebrated in 1950 and all the way through the 2000s is who put it up. So who put this marker up? It is the state of Louisiana. So that is some measure of resistance to the idea that people of color would experience political rights in this country. And then after the season of violence, we get now this new voter suppression tactic, which is to use law, to use the law now to suppress the vote. And so Louisiana officials did not secret their intentions in this regard. So I take you to the 1880 Louisiana Constitutional Convention, where Mr. Thomas Land stands in that governmental body and says, the effect of us denying the right to vote would be to break down all of the colored majorities in the parishes of the state and to place the government under the control and administration of the white man, both for the present and the future. The right of suffrage has been conferred on these colored people, and it is the direful spring from which all of the woes of our people will flow. And then you have the lieutenant governor, same year, write a public editorial and says, I quote, in the Louisiana press, I am in favor of a proposition which will say that every white man in the state shall vote because he is white, and no Negro will vote because he is Black. Now, of course, he says we can't put those words on the pages, but the aim of disenfranchising 75% of the Negroes is the goal. In fact, why don't we just disenfranchise them all, he says. If we leave the right of suffrage to 10 or 20,000 Negroes in this state, these Negroes will hold the balance of power. And what could be worse? Could you imagine a greater curse on a state? And these illustrations are just a sampling. This is not a small matter at this hour in this country. And we will see statements on the record through multiple constitutional conventions as late as 1898, where the president, Mr. Krusenik, brags about the fact that they have now created the poll tax and the literacy test through code, meaning law that does not say that it is intended to suppress the vote, but in fact, that is what was happening. And then we have Governor Murphy Foster, who stands before the legislature in the late 1800s and says, and I quote, the white supremacy for which we so long struggled is now crystallized into the state constitution. There need no longer be any fear as to the honesty and purity of our future elections. And so remember, I said these political rights, the right to vote, the right to sit on a jury, the right to hold public office, were viewed as interchangeable by the Reconstruction Congress. So when the nation was reconstructed, that became the ideology. So if we see this effort being put in suppressing the vote, it is predictable what is going to happen when we get to now the jury box. Guess what takes form? Jury suppression follows just the way voter suppression has happened. And we start to see this jury suppression merge now into the criminal justice law books. So let's talk about some ways that this jury suppression happens. The first way is the way that clerks around the state happen to call folks out for the possibility of even serving on the jury. Presently, many clerks of court in the state of Louisiana use voter registration records exclusively to decide who is going to be called out for the pool of potential jurors. Now, we know that Blacks are underrepresented on the voter registration records, and we know that there is good wisdom around the nation suggested that there are other ways to supplement those voter rolls. So using library records and energy bills and driver's license records are ways that we could supplement that voter registration record to make sure that the pool is calling out more jurors of color. We know that because most jurisdictions will do that out of the state. Yet Louisiana clerks of courts consistently rely exclusively on those voter registration records in calling jurors out for potential jury service, which means that if we're underrepresented in the voter registration records, we're going to be underrepresented, obviously, in the polls of people who are going to be called out. A second voter jury suppression strategy is through the use of these felony disenfranchisement laws, where jurisdictions will say, if you're a convicted felon, you can't participate in the jury box. And as a result, what we see is that is not innocent. That is very malicious lawmaking. And a great example of that we find in the Alabama case called Hunter versus Underwood from 1985. And in that case, Alabama's legislature passes a law that seems very innocent. It seems race neutral. It simply says you can't vote if you've been convicted of a crime that involves moral turpitude. So for many years, all the people involved in these moral turpitude crimes couldn't vote. However, somebody finally sues and gets to the bottom of this, and guess what they find out? The way Alabama officials set up that law was they asked the justice of the peace, hey, do you mind telling us the crimes that most Black people get convicted of? And he makes a list. And then they say, okay, those will be called moral turpitude crimes. So if you fall in this list, you can't vote. And so that's the kind of schemes that we see that we use law now to criminalize people who are affected by certain criminal statutes, but those intentions are simply to suppress the ability of those folks to ultimately end up in the jury box. And the third suppression tactic that I want to talk to you about is called peremptory strikes. And all the way back in 1986, we have a case called Batson versus Kentucky that comes out of the Supreme Court of the United States. And Batson says something quite simple. It says that if you're a prosecutor, you are not allowed to use the race of a potential juror as a basis for removing that person from jury service. So you can have a legitimate reason to remove them, but it certainly cannot be race. So there's one case, a recent case called State versus Maxey, that I want to cite to you as a great example of how this works. State versus Maxey comes out of Manny, Louisiana, which is near the head of this chapter. That's why I selected this one. And in this case, the prosecutor is mumbling under his breath that there's a Black juror, Mr. Sweat, who he doesn't want on the jury. So he's saying quietly to his co-prosecutor that he's stupid. That's literally what he says, but he thinks he's whispering. But when he gets on the record, he doesn't say he's stupid. He tells the court the reason I want Mr. Sweat removed is because of his demeanor. That's his official reason. And then he says, and what I mean by that is when we ask him questions, he doesn't seem to be able to answer these questions well. He's sort of struggling. I think he maybe not be comprehending things. The way he's sort of holding himself out in the jury box sort of leads me to think that he doesn't have the ability intellectually to be able to process this information. So the judge hears this, does not feel in any way this is discriminatory, and so he dismisses Mr. Sweat. Now, this is a significant point because the jury is majority white. So Mr. Sweat's dismissal means that you're going to end up with an all-white jury because he is the minority on this jury as a Black man. Now, what the judge never considered is that there is a distinct history when it comes to race and intelligence in the South. There were scientific journals way back during chattel slavery and beyond that suggested that Blacks were mentally inferior, and these scholars, these scientists, were arguably recognized as experts. And so they taught the world that this was a biological fact, that there is inferiority there mentally. And that became credible, and that became accepted science. That very science was the rationalization for segregation in this country. And so this belief in Black mental inferiority became a part of Southern norms, largely because of scientists who taught us this misinformation. We see it creeping into many judicial opinions, where in the 1800s we have a judge who actually goes on record to say that he's removing the Blacks off the juries. And he says the reason why is they lack intelligence. Although at this time he's doing this, there's a federal law that says you cannot remove Blacks from juries because they're Black. You can't do it race reasons why, but he does it anyway. You have in Louisiana's Constitutional Convention on the official record, the delegates suggesting that they must suppress Black vote because they're corrupt and they're illiterate. They're inferior intellectually. And so the Maxey judge, not having this awareness, not being culturally competent, doesn't recognize that this prosecutor is using a pretext in order to get the single Black juror off of the jury, and they allow him to remove it. Now, I applaud these attorneys because they fought for years in order to have this trial corrected and to have this juror reinstated. And so by hiring a mitigation expert, they were able to go back into court and prove that Mr. Sweat was a high school graduate, the stupid man, the one who the prosecutor said couldn't understand. They were able to prove that he was actually a welder, that he had played a musical instrument, that he performed in a band, that he was a deacon who taught regularly in Sunday school, that he worked along with the church to keep a budget every month, that he had been on another jury in the parish, oddly enough, and that he had a 30-year career in a local plant as a saw operator. And so after that fight and those years of challenges, he was able to claim his seat back on that jury. And then, of course, we know that the outcome of the trial becomes very different because of that. The problem is what happened to Mr. Sweat is the normal protocol in Louisiana courts. And the fight that followed Mr. Sweat's case is highly unusual. So on a typical day in Louisiana courts, what you see is prosecutors stand up in court and give these very pretextual reasons why a person of color should be removed from the jury. And I want you to listen to a few that I pulled just from some actual transcripts. One prosecutor says, the reason I want her removed is that she's a single female with children. Another one says, I want him removed because he enjoys rap music. Another reason, I don't like him because he's a smartass. That is actual quote. Another reason for removing a Black person is that they're Baptists. Another, this is all literally from court records, the person is wearing shorts on the very first day of court. How about this reason that this person is employed at a casino? Or this prosecutor who says this potential juror looks like a drug dealer. And the final reason I share is the prosecutor who says, I don't want that person on the jury because that person is wearing gold teeth and they have on a t-shirt. And so what you see on the screen is the face of Louisiana's former Chief Justice. She's now retired, Justice Bernadette Johnson. And as she discussed this very conversation that we're having in one of her Supreme Court opinions, she says, and I quote, that when the trial judge, as the gatekeeper, doesn't do the job of screening these pretextual explanations that prosecutors give, the court itself is becoming now a party to racism. And the court is using its power and its prestige to enforce discrimination. She's a rare jewel. There are not many justices who will talk to us truthfully about what is happening to jurors of color. So I want us to recognize the legendary leader that we had in her, to go on record to write these dissents and to speak out against this type of judicial racism that people of color face in this country. And so what I'm saying to you in short is that these three practices that we talked about, the failure to call Blacks in by their proper numbers, the multiple strikes of Black jurors, these things ultimately lead to something called underrepresentation of Blacks in the jury box. And what has been done about all of this over the years? In other words, is this a secret? Do Black people understand the situation that I speak to you about? Of course they do. And what have we done? We've done what we've been known to do in this country. We've resisted our own oppression. So what I wanted you to see tonight is just the journey of where we've been over the years as people of color fighting to access the jury box. So just as long as we've been fighting for that vote, you can see that we've been fighting for the jury box. I want to remind you that chattel slavery ended in 1865. So if you're looking at the screen, what you see is that the fight to get into the jury box started even before chattel slavery. So this is in 1864, the free people of color who weren't enslaved were challenging the idea of them not being able to sit in that jury box. And we can see Black people writing to Congress in the 1870s, asking Congress to please stop the suppression of Black jurors in this country. 1875, we get a Civil Rights Act, and what does it say? You can't stop Blacks from sitting in the jury box. So how is it possible that I'm having this conversation with you in 2023 when this law has been on the books since 1875? And then, of course, you can see all of the litigation where people have repeatedly fought and fought and fought for this right to be a part of the jury box. W.E.B. Du Bois, what is he doing in 1948? He is expressing grievances about this long history of Black juror suppression. 1968, Gary Duncan, one of Louisiana's living legends, is fighting the idea of not being able to have a jury to stand in judgment of him at trial. So I want us to fully understand the breadth and depth of this fight that we're in tonight for jury justice. Now, do we as people of color have the right to ignore a social struggle, or are we obligated to finish it? We are here tonight commemorating the life of Violette Neatley Anderson, and so it is appropriate to look to her for that answer. And when we look at her life, we get a very clear understanding that each generation has a duty to act to move the social struggle forward. And with that in mind, there are three things that I want you to know. One, the Constitution of the United States, the Sixth Amendment to be exact, promises the accused person the right to a jury trial in this country. So that is a constitutional protection. The second thing you ought to know is that the courts have interpreted that Sixth Amendment right to mean that an accused person doesn't get to be tried by a particular jury. They don't get to pick that specific jury, but what they do have the right to is a jury that is selected randomly and a jury that represents a fair cross-section of the community. Now, the other thing that I want you to know is exactly who is qualified to be a juror. And you see this codified in Louisiana law. I'm speaking now of criminal juries. This is Louisiana Code of Criminal Procedure, Article 401. And it tells you that to be a juror, you have to be a citizen. You have to be at least 18 years old. You have to be able to read, write, speak English. You can't be interdicted or mentally infirm. And you can't be under indictment or incarcerated for an offense. It also says that, look, there's some reasons that you can't serve, maybe you can't hear, and all of those conditions. So we know what it takes to get on the jury, but let's talk about what it takes to get out of jury service. One, if you're 70 or older, you can say, I don't want to serve. That doesn't mean you can't, but you can opt out. If you're a full-time college student, or if you've been recently on a jury within the last 2 years, you could say that I want out. Now, notice that is optional, so you don't have to opt out. And then if you have a hardship, like maybe lack of childcare, one of the common hardships for people of color is that they cannot afford to take the time off of work. Sometimes jury duty can pay $12 if you're not picked, $25 if you are picked. And for a lot of people, that is less than what they would earn going to work. And so they claim a hardship in order to get out of jury duty. So there are some conclusions that you should be able to draw based on the conversations we've had so far. And one of the big conclusions that I hope that you're able to draw is that the jury box for people of color is actually a site of institutional racism. The other couple of scenarios that I want you to think about is it's either our presence in that jury box is suppressed, or it is that we are removing ourselves from this very precious site of power. So sometimes it is forces that are suppressing our ability to be in that jury box, and sometimes it is us removing ourselves. So what's the problem in either scenario? If the forces don't let us sit in the jury box, or if we opt out of the jury box, what's the problem? Well, here is what I think after years of studying these juries. I believe, this is my opinion, I haven't found this written anywhere except in the book that I'm writing. But what I believe is that a jury is actually the functional equivalent of a diversity, equity, and inclusion office. That's my belief. Now, why is it important that we have this diversity, equity, and inclusion office? Because around 4% of the lawyers in the whole country happen to be Black. So you walk into a courtroom and there's a great possibility that you will not have any Black face in that courtroom. In other words, all of the players in the criminal justice system are predictably white. Most of the time, the police officer who decides who's going to stop and arrest is disproportionately white. The prosecutor who is going to decide the charges, they're disproportionately white. Your trial and your appellate judges whose decisions are impactful when it comes to those sentences, they're disproportionately white. So too often, the only opportunity for people of color to influence that decision-making process is in that jury box. So that's one of the first reasons why this matters. But that's not the only reason. The other reason is there is a body of compelling science. It's called deliberative process research that tells us some really important stuff about group decision-making. And what it tells us is that the composition of who is in that jury box is going to influence the outcome of that decision making. Why? Because people of different perspectives consider and evaluate the very same information in different ways, and they often will arrive at different conclusions. And so the goal, the ideal jury, is to have one that is diverse. And I want to caution you not to think of diversity in terms of skin color, because that is an oversimplification of this. Diversity in the idea of experience, diversity of thought is the goal that we want in that jury box. We know that when you achieve that, when you have some women, some older people, some people of different experiences and different education and different wage capacities, we know that they're going to slow the process down. They're going to ask questions. And we know that when that jury slows down, they're going to make less mistakes. We know diversity is going to give us more perspectives to talk about. And we know that when you get diverse groups together, they oftentimes will not make emotional decisions. We know that diversity is going to make them make more reliable and credible decisions. We know that when they make identifications, they're more reliable. We know that these diverse juries don't just presume guilt, but they fairly judge the accused party. And so when you get this type of diversity, which is the goal, you get more reliable outcomes. So the inverse, obviously, is if the jury lacks diversity, oftentimes it moves fast and it makes mistakes. And so you get these quick convictions that are not reliable. And so now you hear this and say, if this has been going on for this long, how in the world can we fix it? And so I want to take my last few minutes just to give you some thoughts on this, because it can be done. So this first slide is something I found just by searching for people who care about this like I do. And it led me to a group of lawyers in California who said that they were angry at the idea that these all-white juries were rushing and constantly convicting people, and those convictions were not accurate. And so what they did, the Be the Jury folks started a pilot study. And guess what this pilot study does? It ups the juror pay from $25 a day, which is what it was, to $100 a day. Now, by doing that, guess what happened? The people of color no longer had to opt out because they could afford to be in that jury box for that day. And look at the findings here. We can see that it immediately increased the representation of Black folks in the jury box. And in their case, what they stressed to me is they said, Professor Bell, this was not just Black folks. This got Asian folks out. This got true diversity, simply addressing the shortage of pay for the jurors for the day. Another piece of legislation, which is pending, and I'm watching this, is moving really well through the legislature. But if you look in the center box, it tells you that here is a jurisdiction that has decided that we don't like the idea of having these all-white jurors. So what are we doing? We're requiring the administrator's office to collect data so we can figure out if we have an underrepresentation problem. But look at line 2. This is the most important part. They're creating a child care assistance program so that if you want to serve on a jury and you don't have child care, you can get the vouchers. So that creates now this obstacle for people who used to have to say we have a hardship. That is now gone. And then lastly, look at this final one, the summons now. It doesn't have to be mail. We don't have to find you. We don't have to get it back and return because you moved. It can all be done electronic, which is a much more efficient process because we have a higher rate of returns when it comes to people of color. Why? Because they're less secure in their homes. And so they're often renters. And so with renters, they're more mobile. And so they're often not there to get the notices. So that would cure that defect. And then this final piece of legislation is another one that says we don't want prosecutors to have a legal way of throwing people off the jury because they're Black. So if you look at this, Section H helps all of those judges who are not culturally competent, who cannot figure out when a prosecutor is given a racial reason but calling it non-racial. So they list the reasons out and say, hey, if your prosecutor's trying to play this game, don't fall for it. So these are just some small options for change if you're interested in can this stuff be fixed, because I'm certainly convicted about the fact that it can. So when we think of people of color in this country and their history of protests, there's some specific things that come to mind. We always think about people of color galvanizing when there is a dead body on the ground because law enforcement happened to have used excessive force. We galvanized successfully then. We galvanized during segregation, and we galvanized for lots of legal rights through the civil rights era. But our efforts have been shallow and insufficient when it comes to criminal justice. And there has been simply no arena of public life or governmental administration where racial discrimination has been more widespread and more apparent and seemingly tolerated than in that jury box. And the legal system brands a lot of what I've talked to you about today as legal. The first lines of the Constitution tell us that the ends of government is justice. It is not legalities. So ladies and gentlemen, I would like to say to you that we can no longer be married to law while law carries out an illicit affair with injustice. Jury suppression and jury apathy both warrant an organized response. And I call upon you to resist the urge to gather and protest when there is a dead body on the ground. Let's protest way before then. If we really mean that Black Lives Matter, let's protest in life. Where should the protest be? In the jury box. How should we be protesting? By making jury duty both an act of service and the new dimension of protest. And I thank you for your attention. And it's my understanding that you are to have question and answer now.
Yes, thank you. Wonderful. Any questions? We'll take the questions now. Just unmute yourself. Any questions?
I see Mr. Stagg.
Good evening, Professor Bell. It's always a pleasure to hear and to listen to you. It just seems as if we are on even plane as it relates to the different things that we're always talking about. And to see your work on the jury protests and how it lines up with some of the different things that I've been doing with jury selection. It's just a wonderful thing to see. So I wanted to come off and commend you for your work and to ask you particularly in reference to that bill that's in California. They were talking about the electronic means in order to help to reach Black jurors, possible jurors. My question is, do you think that that's something that we could get in the South at any point? And if so, what means do you think would be best for us to accomplish and achieve that?
So I absolutely do. And one of the things that I'm happy to report is that I was invited to speak to the Louisiana judges at their judicial conference. And this is the conversation that I had with them. And I was able to provide each of them a hard copy of that legislation so that they understood that this is about a commitment. That's all it takes. That jurisdiction simply said, we're committed to this and we're going to address it. What Louisiana has done is been sued multiple times. Every time somebody feels there's an underrepresentation, they have to be sued. They have to fight the litigation. And this litigation comes over the same issue over and over. We know that certain populations are more mobile. We know that mailing notices out are not reliable anymore because of people's mobility. We know that electronic communications, even cell phone communications, are more reliable. And guess what? It's actually cheaper. So this is even not just more efficient, but it's cheaper. So when I said this to the judges, 3 of them said, oh my God, this is so good to get this information because we weren't even aware that there was such a movement going. So one of the things that I learned from that, it is not that the folks in office want necessarily to see Black folks not in the jury. It's that sometimes these conversations between academics and the judicial branch is just missing, because there was definitely interest when I sent that. Now, I'm monitoring that legislation, so I get updates on it every day. And once it goes through, you better believe I'll be back in touch. So I do think that is a solution. Just imagine now for courts who have to bear the cost of mailing the notices out. When the person doesn't show up, they have to send a second notice. They sometimes have to issue a warrant and then deal with the consequences of the person having to come back for the warrant. How much more efficient is this? So this is a tremendous, tremendous gift. And it's one that I believe could help us. And I also want to say tonight that, you know, all of us in our spaces do work to inspire change. Mr. Stagg is evidence of that. And I just have to take a moment to encourage anybody who's doing work to never, ever doubt that somebody listens, because he was my student many years ago. And now he is getting ready to be the new Johnny Cochran of the legal field, graduating next month, but has taken on this mantle of jury justice and is doing it with technology and apps now to try to raise awareness amongst people of color. And that's just the inspiration that I see now in our future generation, the technology that he's going to wear this conversation to. So I commend you, Mr. Stagg, and, you know, encourage everyone on the Zoom to continue to do the work of social justice, because you have no idea what seeds you're planting as you speak to people about the changes that need to happen.
Thank you.
Professor Bill, I have a question. And I was just sitting here thinking, I have been voting ever since I was 18 years old. So nearly, well, almost 40 years. I've never received an invite for jury duty. I lived in Louisiana for most of my young adult life, and then I lived in Tennessee for over 20 years. And I thought about that several times and speak with some of my family and friends, co-workers that worked in Memphis, that lived in Arkansas. A young lady told me once she got called for jury duty almost every month. And I was like, how is that? And I've never, and that was in 2005. We had that conversation, and I still hadn't been called for jury duty. So my question to you then is, I'm a big volunteer. I volunteer for a lot. Is there a way for me to volunteer to be a juror? How do I notify the election commission or whomever? Because I vote every election. Everywhere I've been, I voted. So how do I let them know that I'm available and want to serve on jury duty?
Great.
And, you know, Memphis crime, you know, there's always something going on.
Yeah.
So I just can't understand how I've never been picked for jury duty. Mm-hmm. I'm an educator, so you know I'm in the.
Sure.
I'm somewhere in the
you're
system.
Registered and you're available. So One of the things that I'm hoping we leave here tonight understanding is that we have to start talking to people of color about the necessity of them being in that jury box, because we understand through the science that they're often the people who raise reasonable doubt. So one of the things I'm asking everybody is to just start having conversations around your dinner table and with other social networks about, do you realize that just you being there is going to slow this process down and might end up causing the right person to be convicted or the wrong person not to be. But to your question about why you haven't been called, every time I do this talk, somebody in the audience responds with that very question, because they start doing the math and try to figure out, well, wait a minute, you know, there is something going on here. I am being suppressed. Now, here's going to shock you. When we were trying to change Louisiana's non-unanimous jury law, I partnered with the advocate in hopes of collecting data to show how many non-unanimous juries we were using. The advocate did so much more than what I initially asked them to do. And it's published in a series called Tilting the Scales that went on to win a Pulitzer Prize. But one of the things they did was answer your question. Tilting the Scales revealed that by the numbers of registered Black voters in each parish, they should be called by a certain percentage, and they're not being called. So tilting the scales gave us documented facts on every parish in Louisiana. And what we learned is that 99% of the parishes in Louisiana have X amount of Black voters, which means X amount of Black jurors should be called, and they're not being called. Literally, they are not calling us out. So you have that initial obstacle. You can't even get in a jury box because they don't send you out the invitation to come. That's the initial obstacle. The secondary obstacle is when you get the invitation to come, you have prosecutors that don't want you there, so they use the strikes to get you out. And then the third obstacle is people not being aware of the really important obligation and duty of them sitting in that jury box, so they then claim a hardship and opt out, or they answer questions in such a way that they give the prosecutors the grounds to be able to remove them, right? So the prosecutor starts asking you, are you really, really religious? You know, to the point where you might not be able to be fair. You start going and giving them information that can cause them to say this person won't be able to impose a sentence because of their views. So we have so many obstacles, and that is the biggest one. We simply don't even get called out. So now, can we volunteer is the other question. Certain jurisdictions allow it and others don't. So we don't have a uniform rule about that for the whole state. And so you have to check the jurisdiction to see if you can volunteer in. And the other thing is, if you're in that 70-something group, don't say, I'm retired, I'm not going. You know, go anyway. If you're in school, don't say, I'm going to use my excuse, you need to be there anyway. Because literally, this is a matter of life or death. And I say that from a person who spent time with people wrongfully convicted, which is a whole nother Zoom. But oftentimes it's the jury that can stop those wrongful convictions, because they can slow those deliberations down and make a careful decision. We want people convicted when they need to be off the street, because that makes us all safer. But we do not want to destroy people's lives by making mistakes in that jury box and convicting people who should not be convicted of anything. So this is, in my opinion, our civil rights obligation for this generation. As you saw, we have elders who have fought for this right. And we cannot sit down and be apathetic or get distracted with the voting rights issue and not understand that this is all wedded. They're all entangled, because the idea was that we would have no political power. And so suppressing all of these rights is the idea. We cannot allow any of the rights to be suppressed. This is way too important.
Thank you. Any more questions?